Hi, I'm Mike Hamilton with Midwest Capital. Here's a fun topic everyone wants to talk about: beneficiary designations. Retirement accounts like IRAs, 401ks, and life insurance policies are what most of us think of when naming beneficiaries. With blended families becoming more and more common, it's becoming extremely important to keep your beneficiary designations current. Setting up and maintaining your beneficiaries may take a little effort, but your family will be grateful that you did. Now, before we go any further, I'm not an attorney, nor am I playing one in this video, and if you need legal advice, you may want to consult with an attorney. Let's look at naming your estate as your beneficiary. If you name your estate as your beneficiary and you don't have a will, the laws in the state you live in will determine who gets what and how much. This may or may not match what you wanted to happen. If you name your estate and you have a will, and that may be a good idea in some cases, especially when there is a trust involved, but most of the time the plan is to not have your retirement account or life insurance flow through your estate. This is Joe. Joe has an IRA. Joe has a girlfriend, Susan. If Joe dies, he wants Susan to get some of his IRA, but not all of it. He wants half of it to go to his mother, so he names them both as beneficiary for 50%. What happens if one of them dies before Joe does, and then he dies? The surviving beneficiary will get 100% of the IRA. What if both of them die before Joe, and he never updates his beneficiary? The IRA will be distributed according to the IRA's custodial agreement. According to the what? The custodial agreement. Every IRA has a custodial agreement drafted by the company that holds the IRA. It's the booklet Joe got when he opened his IRA that was full of fine print he never bothered to read. The custodial agreement typically says the beneficiary is the spouse or his estate. Now assume Joe, Susan, and his mother are all still living, and Joe and Susan get married. Now Joe wants Susan to get the whole IRA, but if Susan dies, he wants his mother to get it. So Joe names Susan as the primary beneficiary and his mom as the contingent beneficiary. Susan gets 100% of the IRA if she is alive when Joe dies. If she is not, then it goes to his mother, and if she's deceased, then, well, we are back to the custodial agreement. Jump ahead a few years, and Joe and Susan have kids, Jerry, George, and Elaine. Joe still wants Susan to get all of his IRA, but if something happens to both of them, he wants his children to get it in equal amounts. So Susan is the primary beneficiary, and Jerry, George, and Elaine are named as contingent beneficiaries. All of the children are minors and don't have the ability to sign legal paperwork to get their share of the IRA if mom and dad are gone. So Joe creates provisions in his will for a trust to be created for each child to hold their IRA and names an adult trustee. Jump ahead a few more years, and the kids are grown, and George and Elaine have kids of their own. Jerry is single, and Susan divorced Joe and ran off with the gardener. Susan got half of Joe's IRA in the divorce, and the first thing Joe wanted to sign after the divorce was a beneficiary change form so Susan wouldn't get the rest of it if he died. Joe names his children, Jerry, George, and Elaine, as primary beneficiaries, and he wants to include his grandchildren if Jerry, George, and Elaine die before him. Now this can be done by naming each of the grandchildren as contingent beneficiaries. This can be cumbersome and needs to be updated if any more grandchildren are added to the family. This can be simplified naming beneficiaries per capita or per stirpes. If Joe names his 3 children as primary beneficiaries per capita, his IRA will be shared equally among his surviving children. His grandchildren get nothing if any of Joe's designated beneficiaries are living when Joe dies. If Joe would prefer that his grandchildren receive their parent share if they die before Joe, he can use per capita at each generation. This way, if George and Elaine are deceased when Joe dies, their children will receive George's and Elaine's shares divided equally among the grandchildren. The third and possibly most common option is for Joe to use per stirpes in his beneficiary designation. This way, if George and Elaine are deceased when Joe dies, then George's children will receive George's share, and Elaine's child will receive Elaine's share. There are many different ways to name a beneficiary, and we've only touched on a few. Remember, if you don't name a beneficiary, or if your beneficiary designations are out of date, the state or your account's custodial agreement will decide who your beneficiaries will be. Not sure how to set your beneficiaries up or need help with updating them? Maybe the thing to do is to talk to someone that can help. Visit MidwestCapital.net for more information or to arrange a personal consultation. Find out why so many of our clients say, "I wish I would have talked to you sooner."